Welcome everyone. We're going to give attendees a few more minutes to log in, and then we will go ahead and get started. Just so you know, the chat functionality of the platform is enabled, so feel free to submit any questions you have to the group through the chat, and we will do our best to address those towards the end of the presentation today. Just going to give everyone about a minute or so, and we'll get started. All right, we'll let everyone trickle in, but we're going to start the presentation now. So once again, welcome everyone, and thank you for joining us for today's webinar, Managing a Complex Case Virtually, a case study of construction defect litigation in the San Francisco Bay Area. My name is Jeff Cohen. I am Director of Business Development with U.S. Legal Support here in San Francisco, and I will be your moderator for today's presentation. Joining me as our panelists, we have William Marchant, Special Counsel at Duane Morris, Sandy Kaplan, partner and co-chair of the construction practice group at Gordon Rees. Bruce Mayfield, partner at Fenton Grant, Mayfield, Kaneda, and Litt. So again, during the presentation, please feel free to submit any questions you may have for our panelists in the chat feature. We're going to do our best to address some of those questions at the end, of course, time permitting. That all being said, we're going to go ahead and jump right in and start with our first topic, and that is how this case actually began. So Sandy, I'm going to direct the first question over to you. To set the stage for our conversation, can you just tell everyone a little bit about the Infinity Tower litigation?
Sure. Good morning, everybody. The Infinity case started as a large traditional construction defect case in San Francisco. It included 4 high-rise buildings, 650 units, over 16 defendants in the case. There included both OSIP and non-OSIP enrolled parties. So we had a really big mix of different parties, but it started as just a large traditional construction defect claim.
So Bill, at the onset of the case, I'm assuming that the parties were preparing what we'd consider just for a normal traditional construction defect litigation.
Well, we certainly knew it was going to be a large construction defect litigation, so we set up a special master and rules for depositing documents for a special interrogatories and document request across the board that all the cross defendants would have to answer. We had issues regarding the curtain wall, we had issues regarding plumbing, we had issues regarding the below ground waterproofing. So we had sort of different categories of people and experts. And so we were in the process of setting up a discovery committee, which we did, setting up a discovery, who everybody's person most qualified would be. We did that. And then we probably got through all of the PMQs before March, and we had started the experts when COVID hit.
So even though that the case began before the pandemic was on anyone's radar, the parties were geographically located throughout the entire state of California, though, right, Bruce?
Yeah, that's correct. We had parties, a significant number from San Francisco, but we had people in Oakland, Sacramento, Long Beach, Orange County, San Diego, the Inland Empire. So we had attorneys from all over California, and we ultimately had experts from all over the United States. Georgia, Michigan, Texas, you name it. People had experts from those remote locations.
So leading up to March, at this point, it'd probably be safe to say that this was nothing out of the ordinary from most large-scale construction defect cases you'd handle in terms of the logistics and continuing the actual legal process itself.
That's true. It was just your ordinary 8-figure construction defect case.
Exactly.
Some dispute over that. I thought it was closer to 9 figures, but
there you go. So as the case continued under these, quote unquote, normal circumstances, it was taking place for months. But of course, everything changed back in March of 2020, and that takes us really into the bulk of our conversation was the pandemic. So when the pandemic began and the shelter-in-place orders forced us to close our offices, Obviously, all the in-person depositions that were on calendar needed to be placed on hold. So what, if any, conversations were the parties starting to have at that time about how this case could even begin to proceed?
Well, the first question was, how do we, if we're going to go forward and take depositions, how do we do that? I'm a little bit old school. I've never participated much in a phone deposition, certainly never in a Zoom deposition. So once people started thinking about how can we continue discovery, the first question really turned to, how do we take a deposition? How do we manage documents? How can we show documents to witnesses? And how do we even move this thing forward in a Zoom platform when something that no one had ever really done that before? So a quagmire. We really weren't sure how to move forward at that point.
It's interesting. And Bruce, I know you had also expressed some concerns in the beginning as well.
Yeah, well, I'm probably a little more old school than Sandy since he's a young man. And what we were starting was not only finishing plaintiff's expert depositions, we were almost done. We're actually taking plaintiff statistician the day we all learned that the courts were going to shut down, and so was San Francisco. So I was nervous about it. I wanted to take expert depositions in person, and we were starting on a course where all of the defense experts would have been taken remotely over a Zoom format. And I did have concerns about it and a lot of questions about how that was going to work out.
I know specifically a lot of the group members also had concerns about, sharing and viewing exhibits, especially with certain clients of theirs. So it definitely was a lot of concerns at the beginning. And as these conversations started between counsel, Bill, I know you immediately reached out to your court reporting vendor. And for this particular case, it was U.S. Legal Support. And you asked them to join a case-wide call to discuss what kind of options there even existed to keep the deposition process going forward. What were some of your initial concerns that you wanted to address with your vendor?
Well, our initial concerns were, as Bruce said, how to handle the fact that we'd almost gone through all the plaintiffs' experts. Now we were switching to defendants, and we'd be doing them in a completely different way. Obviously, documents were a huge issue. We were still doing, everybody was depositing with U.S. Legal through Box, all of their documents, but we were doing the traditional print them out and bring them to the depositions. And finally, we had people that were getting very used to coming to our conference room and having a nice lunch. So everyone was very concerned that they weren't getting their lunch and they weren't going to get their breakfast and lunch at U.S. Legal when you folks hosted us. There were several people who did not want to do Zoom depos. This is all good. About a month or two in, we'll be back in the offices. Let's just wait it out. And then there were some people who were very enthusiastic about it because they had offices in Los Angeles. And they were tired of coming up and, trying to schedule their depositions. They're trying to, block the plumbing depositions for 1 week. So they just have to come up rather than go back and forth. So those were the main concerns. And when we reached out to U.S. Legal, you folks were in the process of doing your platform. And so we met with you and we scheduled a mock deposition to show people how everything would go, because everyone was uncomfortable with how would we use box.com? What would happen? How would we share documents? What would the witnesses look like? And we'd have different attorneys had different levels of comfort with appearing on a Zoom demo. And so those things we worked. So we took two of the sort of more contentious attorneys that had a sense of humor and put them on each other and just set up a mock deposition and watched how it would go.
That's great.
Yeah, as Bill said, the biggest concern I think the parties had, once understanding how they were able to view an expert or view a witness and how you would control your witness, is trying to work through an interface between the documents and how can I get the documents that I don't want to yet show an expert, and how is that set up and how do I move that into a box or that everyone would be able to see the exhibit. And it worked pretty well. Once we went through the mock deposition, I think people became much more comfortable and understood that it was a process that we could actually make work.
I think even before we got to that point, some concerns that had been expressed even on that initial call were, what are the remote options? Because at that point, nobody had taken part in any remote depositions outside of maybe telephonic. So a lot of the questions even were, how do we do video communications from my house? I don't have a VTC unit. I'm not used to this in an office. And then as we continue those conversations, I know some parties had also expressed concerns of witnesses being sworn in remotely rather than in person. Sandy, do you recall any of the conversations parties were having regarding California Rule of Court 333C and 333D?
Yeah, we do. Those were one of the first questions I think we all asked ourselves, which is, can we do this remotely? And are these depositions going to be admissible in court? And since the court reporter is not going to be sitting next to the witness and everybody's going to be, remote. We worked through those issues. We were in a complex department in San Francisco. So I think at one point we even touched base with the court, and we were able to work through the rules of court to allow the witnesses to be sworn remotely. But it was really the first question that we addressed, because we didn't know how it would apply out and how the court reporter can work through the issues.
And I know after and even during that initial call, some of the main topics that we were addressing, Bill, if you want to dive into this as well, we were really talking a lot about how the remote depot platform was going to work and what you were going to be able to do. Bill, do you recall some of just the ins and outs we were discussing of the questions that the group was talking about there?
Well, the first question, as Sandy said, was the fact that the court reporter wasn't going to be with the witness, and some witnesses were going to be out of state, and how we got around that. And U.S. Legal had a admonition set up where the court reporter would come on and for the first 2 months constantly had to say her spiel about everyone's agreeing to do this. So, and eventually the court changed the rules and allowed us to do this without that. The documents were on box.com. We would get I set up a calendar that I would send out to everybody at least weekly and include U.S. Legal on it. So a person at U.S. Legal knew what the depots were and when they were. And then they would send out an invitation to everybody, and the people could sign in if they wanted to. Obviously, we had a depot technician, which I would recommend, who would come on and help us load documents into the platform. One of the first issues that came up and in the depots, and this was pre-Zoom, and Bruce, you can talk about this also, was who's going to pay for all this? That is, we were having all these expert depositions, but the deposition of the curtain wall expert, and everyone's saying, well, I'm not paying for that. So we came up with a rule that all of the parties that attended the depot would share in the cost of the expert and the cost of the depot. So those were some of the issues that we had to work through logistically. It turned out I would just sort of be the point person. I'd send out the calendar, and then U.S. Legal would contact me the day before the depot and send me an email saying, Mr. Marchant, is this happening or not? A lot of times calendar had moved. I would tell them most of the times everything was on par. So we always had a court reporter ready. We always had the videographer ready. We were well taken care of.
Now, Bill, actually, to stick on that for just a moment, you mentioned a couple of the different services, the deposition technician, the videographer. As I recall in that initial call, there were also concerns about, just as a group, what services that you could even request in a remote setting. Because during the in-person portion, people wanted videographers present, people wanted a real-time transcript feed, maybe an interpreter. Do you recall, how we were talking in what could be offered even in the remote setting? Because like you said, nobody had even participated remotely at that point.
Yeah, so we had 3 or 4 attorneys who wanted live note or depot note, whatever their program was, so they could watch the testimony and go back and look at it and read it during the depot. You met with those people and arranged for that to be done. Videographer, we could record the depots, and everybody knew that we could record them, and there would be a recording available if necessary. So that actually helped with Zoom. We had a lot of people who were very concerned about the documents and how that would work, and having the depot technician there to help people load the documents was key, because between the 16 different law offices, we had some people who were loading in documents and everything was fine and they'd set their folders, and we had some people who literally asked, how do I upload a PDF? What's that? So we had the whole range of people on this. And for the people who wanted to have someone's report, they could just give the Bates number to the depot tech, and he could go in box.com, find that deposition, that expert's production, and load that report, and it would come up as an exhibit and get marked as an exhibit. So everybody, especially the asking attorney, would have a private folder. So you'd have a folder in Box that you could load everything you were going to use, like it would be your briefcase. And then as you went through, you'd just say, Paul or John or whoever was the depot tech, could you please load document blank as the next exhibit in order? It would pop up, everyone would have it. So it ended up saving a lot of trees and being pretty easy at the end of the day once you got used to the system. You know, I think we had talked about, you know, for a lot of these witnesses, we probably wouldn't have gone back to regular depots. We probably would have continued to do remote depositions for a lot of witnesses.
Right. So it really sounds like, to summarize, that call that we initially started with all counsel and the court reporting vendor, it was a long call. We discussed a variety of topics, just from how you can have a remote deposition to what types of technologies existed, what types of services you can still expect. Obviously, that long call talking about numerous topics had everyone feeling a little bit more confident afterwards. But Bruce, after that first call with the vendor, was the group ready to just start proceeding with remote depositions?
Not everyone. No, they weren't ready to do it, because that first call was simply an overview of how this could work. And so the real question was, can it work? And we saw a presentation from U.S. Legal, and I think most parties were convinced that if there was a willingness to do it, it could work. But, you know, everybody wanted to see it before they would believe that it could happen. And that's when we had the mock deposition, where one of the attorneys for the defense examined another one of the attorneys for the defense. And of course, it was pretty humorous, but it also was very instructive and made people, even nervous ones like myself, a lot more comfortable. But obviously, when you listen to Sandy and to Bill, I'm sure you've already guessed that there was an enormous amount of cooperation among the parties here. The parties wanted to go forward. They didn't want to go into limbo after everybody had been taking depositions since June the year before of percipient witnesses and then expert witnesses. Everybody wanted to go forward. They didn't want a hiatus. And at that point in time, we had a trial date in July, and we didn't have any indication from the court that that wouldn't be a good date, except for the fact that San Francisco shut down, and the courthouse was actually pushing trial dates and other significant hearings out about 90 days. So in fact, what happened was the parties did make agreements to go forward using a remote deposition platform. And also there was agreement among all the parties to continue the trial date into October, which ultimately was the trial date. The parties had to prepare for trial and a remote jury trial at that time. So if we hadn't had this willingness to do it, we hadn't had significant cooperation from all parties, it never could have been done, no matter how good the remote platforms were.
One of the remote platform issues I think that we were concerned about was, how do I communicate with my expert? You know, you're not sitting next to them. You can't put your hand out. You can't tell them stop answering. You can't, you know, they're sitting in their own home away from you. And so we really had some concerns about, how do you control the expert or even the percipient witness, and are they comfortable? And I think everybody realized, you know, between objections and going offline and speaking offline, you were able to manage that. But I think that was another real concern with a lot of parties, which is, how do I deal with an expert who's not next to me? Can't be taking cues from me if they're you know, about how to be responding, or if they're overstating questions, and how to make the objections. The mock deposition helped that, I think, with a lot of people understanding that that was something workable and something that could be overcome. But there was a lot of concern as well about, how do I deal with witnesses who are I'm not sitting next to, and making sure they understood the question or responding to the questions as they've been asked. Now, this was primarily with experts. Recipient witnesses, I think some people may have wanted to go in and be next to their witnesses during those. And we actually had one or two depositions, as I recall, where the expert, the attorney and the expert went into an office. They were sitting 6 feet apart, but they worked together for some of those attorneys. That was the rare exception, but that did occur with some people.
I don't think it could be understated the importance of the cooperation between all counsel in this case, especially to have the preparation for the expert depositions. Understanding that generally speaking, everyone had the same concerns. It kind of brings us to the next point, Bill. We were going through these platform demonstrations. These were a lot of the conversations that they were generally communicated by all counsel. And I know one of the main issues that was brought up was just the lack of tech savvy knowledge for maybe some of the attorneys, and not only the attorneys, their clients. Do you recall any of the conversations that happened about how do we deal with our clients who do not have the tech background to understand this platform?
Yes, I mean, we just worked through that, quite frankly. We had some experts who spent probably the entire Zoom deposition talking like this. You know, you just had to try to teach them through some things. It was various levels. And then we had some attorneys who just didn't Zoom. They called in because they had done phone depositions before. They were just not comfortable being on a Zoom deposition. They had Zoom fatigue of trying to see, you know, I only have 4 pictures here, but if you have 16 people on the screen, it was difficult. So the depo tech saved us on several depos where the person really took someone who might not have even been able to attend and would have been objecting, and within 10 minutes had them set up in such a way they could participate in the deposition. So for us, that was important because, and we had 2 or 3 counsel that were still insisting as of, you know, July, they still said that we should be discontinuing them and waiting for this to be over so that we can have live depositions, because they didn't want to go forward with them.
It was
As I recall, we set up numerous training sessions, not only for the firms, but also for specifically the deponents, so that we could get on before depositions, let everyone click all the buttons, understand what could go wrong, have work solutions brought up to them. And I think that was one of the most important things as we prepared for your remote setting, was not only that you were comfortable, but that your clients felt comfortable. Because at the end of the day, if you can't produce a client who's going to be able to provide testimony in an accurate way, we're going to have issues regardless. So kind of sticking with that, after all of those training sessions took place, and I know, Sandy, you've already alluded to this, tell us a little bit more about the mock depo. What was the best, what was really working for us in that setting? What did it allow everybody to do in order to prepare themselves fully for the real depositions?
It allowed us to first be able to understand that we could see everybody. You could see the deponent, so we have the screen set up so you're constantly looking at the deponent as they're being answered. And so that became a comfort level once you understood you could see people and see their how they responded. And the second thing we were able to do was understand how we were able to pull it out of the box, either working off a separate screen or out of your private folder. And I don't know if you explained, everybody had a private folder that had to be set up that you would put documents in. And then when I wanted to show a document to a witness, I would then move that document or have the tech move that document into the joint folder. The mock deposition allowed us to be able to see how that worked and be able to relatively seamlessly show that we could have a document shown to the witness, and the witness was able to view that document while we still could see that witness itself. The other thing we were able to do, and this came out during the depositions, is if there was a document the witness wanted to show us, we had opportunities where the witness was able to share his screen, and we could work through documents as though we would lay it out in front of a table. And so we would go away from looking at everybody and we'd just have a shared exhibit, and the witness could be able to walk us through like curtain wall detail, for example, or a low grade detail, and explain to us how that detail supported their opinion. That was something that we didn't do in the mock deposition, but found worked relatively well during the actual depositions of a number of the experts.
Bruce, did you feel that at the conclusion of that mock deposition, not only yourself, but the majority of parties were ready to just say, let's go for it, let's take regular depositions and we'll work out the issues as we go?
Yeah, I think at the end of that demonstration, the mock deposition, parties became a lot more comfortable with the platform and agreed to proceed and try it. course, anyone who wanted to was free to object at any time to it and to take their concerns either to the referee or to the judge.
I think really the main takeaway from this entire topic that we're discussing was the communication was constant and very clear from the counsel to the vendor. And that was what really enabled us to continue this case, was how to express the platform's abilities, the expression of concerns of the group, to go through every possible scenario prior to it really happening, especially with a group of this size on a complex case like this. It was that constant communication, that cooperation between counsel that really led everyone the comfort they needed. And just so everyone on the listeners is aware, this then continued for months. We started taking depositions. I think we were double and triple tracking at times, and we were really progressing for an aggressive trial. I know Bruce mentioned as we progressed towards that trial, that started to become a very large topic. So with that in mind, I think we're going to jump into our next topic, as that was the lead up to the actual trial itself. And as a spoiler alert to all the listeners today, the case actually did achieve settlement the day before trial, so we did not end up implementing this trial strategy that we developed. But the parties were under the assumption that this 4-month trial was going to be taking place. So that being said, Sandy, what was even the conversation of how a trial could go forward given the state of the pandemic at that time?
Well, we were in the complex department with Judge Mazzullo in San Francisco, and she was insistent that this case was going to go to trial. And it was probably the first large construction case, that San Francisco was going to try, civil case. And she really brainstormed with us every different way to move this case into trial. She talked about jurors being remote. She talked about how we would be able to have the 16 lawyers set up with everybody 6 feet apart. So there were a lot of logistics that we had to overcome. I can tell everybody that all the attorneys objected to the jurors being remote. So while the court was pushing that, even to the extent at one point of suggesting that the lawyers all consider supplying laptops to jurors if they were at home, there was an objection to that. And so she didn't push that too hard, and we were going to start with the jurors present in court. But we really had to deal with the logistics of 16 lawyers, documents, a 4-month trial with 12 jurors and 6 alternates, and how we would logistically be able to accomplish that. And it was a lot of work to be able to start figuring out how to do all of that.
I mean, it sounds like a very complicated preparatory process. And Bill, what was really the approach going to be for this hybrid-esque trial?
Well, the court had started getting ready for trials in general, and she had sort of amped it up where they had numbers that they had put on the different chairs. So she was going to have 12 jurors spaced, 6 in the box, 6 in the gallery, and then space for the attorneys. There would be about 8 of us. That was in Department 304. She also had 303 vacant. So she was putting the 12 alternates in 303 in the same format, and every attorney wanted to be there. And there would be a Zoom feed from the main courtroom into the other room, and similar to the feed, and then there would be a feed to the public too. We got questionnaires for 650 jurors. We were going to do jury selection the Monday, after we had finally settled, but we had all set with starting jury selection in the main jury room, where they assemble in the basement. And she had 52 chairs, socially distanced, set up for the potential jurors, 17 chairs for all the counsel and herself, and then a Zoom feed into the courtroom so the alternates could be sitting up there and be brought down if people got challenged. So she had that worked out. We did convince her that we were going to have jurors in place. However, she warned us that the first time she heard someone coughing, we most likely were going to have the jurors sent home. So we had that over our head. We never resolved that. We didn't have to. She had ordered plastic shields for the witnesses. She was going to give them Clorox wipes. She was going to have wipes for all the attorneys. We were going to have depot techs sitting behind us that would also do all the exhibits. And then the defense was going to have one person help them, and the plaintiff was going to have one person help them. So using the box.com platform that we had used before for the depots, we had all of those documents ready to go if we needed to bring them up as exhibits.
So there was going to be this hybrid approach of certain people physically present, certain people remotely attending, a Zoom feed from one courtroom to another courtroom, also a Zoom feed from the courtroom to the general public. And it just sounds like a very complicated plan. And as you mentioned, if somebody got sick, there had to be some contingencies in place. So speaking of that, Bruce, can you speak a little bit more about what the plan would have been had we had individuals contracting COVID, or even as the judge put it, just the common cold, they didn't want to risk it?
Well, the plan was to go 100% remote. And Judge Masulo made it very clear that if anybody in the courtroom, the clerk, the bailiff, the judge, a lawyer, a witness, showed signs of being ill in the courtroom, that's exactly what would have happened. We would have gone 100% remote. And one of the things that we pursued in the juror questionnaire that was sent out to the 650 jurors was what technical skills they had, what devices they had and knew how to operate, what was the level of the type of internet they actually had access to in their homes, whether or not they had spaces in their homes where this process could take place, and were these spaces ones where there wouldn't be interruptions by, for example, children or dogs or other members of the family household, so that we can explore that with the jurors throughout the voir dire process. Could we be confident that they would pay attention over a 4-month trial? I mean, I think that was one of the things that concerned all the lawyers. I mean, it's not like this is the most exciting topic, construction defects, even if you're in the courtroom where a lot of annex go on that keep you interested. And if you're in your home, you know, it's hard to keep people interested. We explored those topics, or we're going to explore those topics with the jurors had the voir dire gone forward. So that's one way we prepared. Sandy mentioned that the court suggested that perhaps we'd want to get computers for the jurors. And I think if that had become necessary, for example, plaintiff would have stepped forward, and if the defense wasn't willing to contribute, provide computers so the trial could go forward. After all, we'd gone this far, and everybody had invested a lot of money, including the plaintiff, and we'd want to conclude it. You know, it's like trying your first jury trial. I did it as a district attorney. You know, you're frightened out of your mind, really, no matter how long you prepared to try that a speeding ticket in front of a jury, but you just have to step off the ledge and do it. You know, the fall is going to kill you. So what does it matter if you can't swim? You've got to start somewhere. And, you know, there's a lot of predictions about whether or not society is going to get back to where it was quickly, even with vaccinations. And I think the answer is no, it's not going to. And so we may be facing the necessity of going forward remotely, not only with depositions, but with jury trials. Multiple parties reported that their experts, who, as I said, were in Texas, Michigan, Oregon, Louisiana, and all over the United States, really, some of them were expressing the fact that they did not want to travel during this COVID crisis. So in order to I guess, achieve justice for all parties, we're going to have to make some compromises, and we're going to have to cooperate. And I may not know everything about technology, but what I do know is that there's somebody out there who does, and they probably have a solution to the problem if I'm just willing to listen and learn how the technology works and work with a good group of lawyers like the ones in this case to make it all happen.
You know, Jeff, I think the key for us is, while everybody did not want to have the jurors remote, we were committed to this work in the space that the court provided to us. And of course, the court didn't have any of the ability to provide any of the equipment for us other than a plug and maybe a overhead screen. So we looked to US Legal. They were able to set up our 2 courtrooms with the video cameras that were scattered throughout, so that the jurors and the attorneys who were in the remote courtroom could be able to see what was happening in the courtroom. We'd have a bailiff sitting in the second courtroom with the screen showing the witnesses. And In the main courtroom, we had everybody having to sit 6 feet apart. So we had multiple screens and cameras set up in that courtroom as well. And then we had, of course, since all of the exhibits had been electronic, we had the techs ready to throw those exhibits up. And so I think we had to set up, with your help, a lot of the technical material, equipment necessary to be able to go forward with that trial in person. And as Bruce said, we were going to have some experts who were just going to testify remotely. They were not going to get on a plane and fly from Texas, for example, up to the Bay Area to testify. And so the court was working through how we would show witnesses via Zoom to the jurors and the attorneys.
It brings up an interesting point, because even though the trial did settle the day before it was set to start, we had these discussions about, if this was a remote trial, what processes would need to take place, similar to how we prepared and trained for the depositions, because obviously the individual members of the courthouse, the individuals who had not participated in any depositions, whether they be witnesses or jurors, they would need some type of training for preparing for the technology platform. So, Bill, was there any kind of conversation about what would need to happen if this did go fully remote after the start of the trial? How would we be able to prepare the individuals to participate who were not prepared before?
Yes, we had to, because she had thrown the warning sign a week before we were supposed to start that was going to happen. And when she got all the objections, she just looked at the defense counsel and said, "I hear your objections, overruled. You've made your record." I think one of the reasons we were worried about getting into Zoom depots at first, and Bruce can back me on this, was people were very concerned that it was not going to be near as effective as an in-person depot to read the witness and to get a record. And very soon after we used the Zoom depots, as long as those witness was a good, had technology, we found that very quickly it was an effective way to read a person. So one of our conversations about trial was how we were going to get that across to a jury with a witness. That is, how we could properly frame the judge being able to give them feedback that they could read, the attorneys and the witnesses at the same time on a Zoom platform. And we didn't get to try that, but that was one of the things that we talked about with your technicians for a good week. Also, how to handle the exhibits and how we were going to do that. And that is sort of more straightforward because we had gone to electronic exhibits and trials over the last 5 years. So that wasn't the hard part. The hard part was getting the Zoom to a point where a juror could really effectively read a witness and read the counsel and get some of the nuance that we're losing when the jurors weren't in the courtroom.
And I know that's something that Bruce had brought up as well, was that if this was a fully remote trial, the ability to gauge a juror's response to the line of questioning, to really understand them, because obviously in person you can hear the gasp, you can see the oohs and the ahs if that's what's happening. But the concerns also were, how do I view this pool of jurors on a remote platform? And I know Bruce had a couple of solutions that he had discussed, working with his team to have them specifically watching. Bruce, if you want to talk a little bit about those concerns as well.
Well, certainly that is a concern, because you want to have some way to judge how the jurors are reacting to your evidence. And of course, when you're not the examining attorney, you can turn to a screen and see all of the jurors who are participating, and you can gauge their response to the evidence that is coming in. However, when you're examining, you can't do that. I strongly recommend to anybody doing remote depositions or anticipating and proceeding with a remote trial that you're going to literally have a team. It's going to take a village for you to present your case and monitor everything that you need to do. There's quite a bit of literature out there on the internet about depositions being taken remotely, trials going forward remotely, really all across the country. Seems like the courts and judges have warmed to the idea that this is going to become a necessity right now, and they've gone forward. And they're recommending to many lawyers and judges that they have multiple screens up. But this, of course, brings up the issue of the jurors. For example, if you throw up a document for a juror and all he has on the screen is the document and he can't see the witness, then he's really not getting the benefit even close to what he could in trial, where he could see the document, and turn his head to the right or to the left, and see the witness and see what he thinks about their presentation, their credibility, their understanding of the document, and their interpretation of it. So that's one thing that we did not spend enough time dealing with, and I'm sure it would have come up during the trial. You have to make sure they'd have large enough screens so you could have a split screen where they could both see the witness and review the documents. And of course, these are issues that we just have to, as lawyers representing our clients, think about going forward.
It's interesting. Also, with the actual courtroom itself and the setup, and we talked about preparing those jurors to be able to actually ingest the information if they was participating remotely. Do you feel, Sandy, that had we gone fully remote, initial trainings for the jurors would have been required so that they understand exactly what the flow of the day looked like?
Oh, absolutely. I mean, we never really entered to that part of the case because, quite frankly, the lawyers were almost universally opposed to having the jurors remote. And it would have taken some significant discussion, I think, with the court as to how to move that forward. But it would have required, I think, jurors to be trained on how to use the computers, how to be either, whether it's a one monitor or two monitors, to have a split screen so they can see the exhibits. We never really got to that stage of the discussion, but it was a real concern if we had to go through that with jurors. It took a lot to just show our experts that they could go online and participate and be deposed and work and be able to answer questions. It would have taken a lot more training with the jurors. We didn't even know if the jurors had the internet capability to be able to Zoom, and so we had discussions about, we have to give them laptops. How do we get them back, at the end of the trial? How do we make sure they have enough bandwidth from a Wi-Fi system to monitor them? What happens if one computer freezes for one juror? How do we learn about that? And so there were some logistic problems that, quite frankly, we never really overcame if we had to be totally remote with the jurors. Those are issues they were able to work through in depositions. And, there were 1 or 2 days in depositions where if someone's computer just froze or the bandwidth isn't working that day, we were able to continue the deposition for the next day. The trials would have been more difficult if we had the jurors remote. But I think we had the system set up well enough that with the jurors present, other people would have been able to be remote. And I know there were a lot of lawyers during the trial who were involved with particular issues that did not want to be in the courtroom every day for 4 months. And so we had set up the ability for those attorneys during the trial to be remote and monitor the trial remotely. And we have clients who wanted to be able to monitor the trial remotely and would be able to do so via the Zoom platform. And the court set up a way where they were not going to be able to answer questions. They would have been muted. But there was the ability for people to participate in the trial, the attorneys and clients, to monitor not being in the courtroom. And the court encouraged that because we only had so much space, everyone having to be 6 feet apart. So she was pushing for us to have the ability to be remote for the attorneys and clients and potentially some witnesses.
And all in all, it sounds like this case, between the discovery process of depositions leading up to the trial preparation, it was just more preparation than maybe we would say in a normal circumstance. Conversations we had never had before, concepts we had never even discussed in terms of the feasibility of doing something like this. But the key takeaway that I felt during this entire process was, again, the communication between not only counsel, but counsel to the vendor. None of this is possible if both the vendor and the counsel are on different sides. They don't understand where each other are coming from or what the concerns are. I think that this group did a great job of expressing exactly what they hoped to be able to achieve, and the communication was clear enough that we were able to provide those solutions to the process of the actual deposition process and trial preparation. So I guess really what that brings us to is the lessons that we learned from this circumstance. And I think an interesting one to start with is post-pandemic. I guess, Sandy, would you continue to use this type of remote methodology for depositions, or would you prefer to go back to an in-person lifestyle?
I think it's going to be mixed, to be honest. I still enjoy going to the deposition and looking at the witness face-to-face, but I don't think that's going to be the case in every deposition. And I think this has taught me certainly that Zoom depositions are not going to go away after the pandemic is over and hopefully life returns somewhat to normal. And I'm sure we're going to see depositions almost routinely being a mix between Zoom depositions and depositions where you're going to be in person. Me personally, if I have a lay witness who's never been deposed before and is going to be nervous about the system, I'm going to want to be there in the future. But I'm certainly there are going to be depositions where it's easier, less expensive, more economical to participate via Zoom. And I think we're going to continue to see that even once we're past this pandemic.
What about you, Bill? Would you prefer to go back in person, or could you see yourself continuing the remote process?
Well, it depends on the purpose of the deposition, I think. I think that one of the things that I think we miss in Zoom depos is all the time in between testimony when the attorneys talk to each other about different issues, and that you lose a lot in managing a case like this and the issues like this when you lose that. That being said, I mean, I'll never forget sitting in a gym in February last year and hearing some guy say, "Hey, Jack, have you heard about this virus? I just invested $150,000 in this company called Zoom. I think it's going to do really well." I'd like to meet that person now. Everybody was, I think, very surprised at how well you were able to read people and how well you were able to communicate through Zoom. And so I can see in the future maybe having something where there's a chat room, a side room where the attorneys can talk to each other on Zoom in breaks during deposition, something like that. But for witnesses that are peripheral and are, authenticating documents or, just clarifying that they don't really know anything, I think Zoom depositions are here to stay. I think it's a much more efficient way. And especially when you have multiple attorneys, being able to get on a call and spend 1 hour, clarifying what this witness knows, rather than spending the whole day, traveling, really makes sense.
And I know, Bruce, at the onset of all of the remote process, you definitely had a lot of concerns. So I'd be curious to hear, would you want to continue taking remote depositions, or would you default back to the in-person methodology?
Well, I agree 100% with Sandy and with Bill. I mean, it's going to be mixed going forward. And frankly, taking an expert's deposition on Zoom, where you can, through the Zoom technology, pin the witness. So they're speaking, as long as they're looking forward, speaking directly into the camera. You can look directly into their eyes. I think you can read them as well as when you're in person. But I think it's going to be on a deponent basis, and also involve, as Bill mentioned, what is the area that's going to be covered? How important is it? And on the more important depositions, I think you're still going to want to, if not for all of them, and we took many experts for 1, 2, 3, 4, 5 days, and some 10 days and 14 days. So there's going to be some where you're going to choose to be in person, both with your deponent who's getting questioned and with the deponent who you are questioning. And again, it's going to be mixed. But there's just so much cost savings, so much time savings for the attorneys who are very busy. Not many have the luxury of having a single case going forward at one time. And so Zoom is going to make that easier on all the attorneys, in addition to expert witnesses who some refuse to travel, some don't have the time to travel, so their depositions get set out, days, weeks, sometimes months, because of that consideration, where if you could just go on Zoom, they'd be available next Tuesday. So I think it's going to be mixed. I think what we're going to see is this whole technology is going to grow and going to have a lot of changes in it and become better and better and better, as all technology has.
So Bruce, I'll stick with you here. For speaking to somebody who maybe has not participated at this point in either a remote deposition or has a large scale litigation that they've pushed off, so to speak, in hopes that resuming in person was possible, what would you feel is the most important advice you could give to that individual, whether it be the training? I know you harped a lot on having a deposition technician present. What would you really say is the most important thing for somebody just new to this type of practice?
Well, the first thing, of course, is try it. You'll like it. And if you don't try it, you'll never know, and your case will stagnate and will not go forward. And pretty soon you'll be staring down the the risk of the 5-year rule passing. So you've got to try it. And the second thing is, don't be too nervous about it, because it actually can work out. The technology is great. We have people like U.S. Legal who are willing to teach us and work with us and set up mock trials, and that's important. And you have to, as the attorney, I think, just remember you're going to have to essentially prepare, and maybe to some extent it forces a little more preparation, which in these large cases where each deponent can be significant is important. One thing I would observe is you're going to have to be prepared for things to go a little slower. And I don't really mean depositions as much as I do trials. We didn't get to go to trial here, we settled. But everything I've read about people who have actually proceeded to trial, including a trial that was actually tried by Judge Masulo, is that everything's going to take longer. And we actually had a very tight trial timeline in this case. And if everything took longer, it would never have been finished in 3 months, probably closer to 5 months. So I think those are the things you're going to have to consider. But if you want to go forward, and of course the client always wants to go forward today as opposed to next year, you're going to have to embrace this technology.
You know, Jeff,
Sandy,
I think
I'll pose the same question to you.
Yeah, I think one of the things I'd recommend to people, certainly at the outset, is to invest in that trial or that deposition technician who can help anybody get through any glitches. We had them all the time. Probably towards the end, we didn't need that technician as people became more comfortable. But the technician was able to clear up any problems. We had a witness that I can't get on the internet, I can't turn on the computer, or I can't get my video to work correctly. They were able to work through all of those glitches for us, moving documents around and showing the documents became much easier with the technician there. And if there was a glitch, they were able to solve that problem. And so if someone has not done this before, I think that's money well spent. I know that's the support that U.S. Legal provided for us. As we moved through it and people became more comfortable, that technician some days didn't say a word, you know, and you may be able to save on those costs, you know, once you become accustomed to the process. But I think that's the first thing, you know, that I would recommend to people if they're going to go down this road, because it really did help in making the process seamless and dealing with any computer glitches that invariably would show up. And I think, as Bruce said, in the beginning, it's just going to take a little bit longer. You know, the deposition might go an extra 20% longer than it would normally until people became more accustomed to the process. But once you got into it, it worked well. And finally, I think it does take a little more prep from the attorneys. I mean, you've got to take the documents that you want to be using if you're going to be questioning that witness, put them into your private folder, and then move them in at the right time, or pre-mark them so that they have the documents ready to go. But with all of that and the experts becoming accustomed to the process, I think we're going to see more and more of these type of Zoom depositions.
And then Bill, I'll also ask you the same. What would you give advice to somebody who's just never done this at this point and has to do so some point this year?
Well, first would be, I think the most important thing is what you said, which was the communication with the vendor is key. You have to have a person that can rely on you and you can rely on them and you can get a hold of them whenever an issue is about to come up. Many times I would just say, hey, is this depo going to go forward? And we were able to figure out when there were problems. The documents are key if you're going to do remote. With multiple parties, you will want to have a depository so you can share them that way easier. With smaller cases, I've had it where people actually load documents onto the chat and you can just click on them and download them and then you have them there that way. That only works really if it's a very small case. I will say that one thing that we noticed, there were a couple times late in the case where someone actually brought their expert and put them in a conference room and sat across the table and did the old style video. So it wasn't, I mean, it was on Zoom, but it was more like a video conference. And we all were very agitated because the expert was like this. I mean, he was a little tiny dot. And we had gotten so used to this and being able to read people. So I think going forward, even if you have someone in the same room, Sandy, I think you might have two different cameras so that the attorney and the witness are on as if they're in a Zoom, even if they're in together. So the prep, witnesses, and then preparing your witnesses is more difficult. You really have to make sure you do a dry run with them before you put them on a Zoom call.
And finally, I would say this now at the conclusion of the case, knowing what we know now, Bill, I'll stick with you here to start. Is there anything, knowing what you know now, that you would have done differently or preferred to have set up in a different methodology? You mentioned obviously that towards the end deposition, you saw some camera views of experts farther away. Now, obviously knowing that that could have been a potential issue for you, anything that you would have changed or preferred to do a different way?
Not really. I think that maybe to make sure that there's a uniform way that people are depositing their documents so that we don't run into technical issues there that cause problems sometimes. And then, like you said, just make sure that everybody has sort of a uniform way they're presenting their witnesses on Zoom.
Andy,
Other
same to
than
you.
that, I'd be very complimentary of your staff. Yeah, your staff did a great job and helped us out a great deal.
Thank you.
We did a good, I think we were able to use the exhibits. We pre-marked exhibits. We had a numbering system that allowed us to just sequentially go from one exhibit to the next. Even if we were double tracking, we had set up something ahead of time, numbering system ahead of time, so we were able to call out documents from different depositions, show them to the witnesses. That took a little legwork, but I think that's gonna, that may have taken a little more work ahead of time to make sure that was set up correctly. But once that system is in place, I think it makes it a lot easier to move forward with these depositions.
Finally, Bruce, anything you would have done differently knowing what you know now?
Knowing what I know now, what I would have done differently is start earlier, getting ready for this, and ensure that we have the court's recognition of the fact that the trial may have to go remotely, and that we're going to have to train the jurors on how to use equipment and devices that they may already have, and that's going to take time. So you got to start very early in order to prepare to get your case ready for trial and to make sure that the other parties are on board, which is going to require some conversation and some cooperation. You can't do it at the last minute. I mean, we didn't have a lot of options. We were in the middle of the expert depositions. They had to be completed. We didn't learn until March that COVID was going to interfere with the jury trial going forward. So we had to both juggle that, getting it moved into October, juggle the ongoing depositions and the remote deposition process, and then juggle along with the court, who expressed great willingness, well, not only willingness, but in her situation, the case was going to go forward. It was getting older, as many of these construction defect cases do, and she wanted to see us hold the trial remotely or in person or a combination and work toward that. And if we started a little earlier, we would have thought of a few more things we might have wanted to accomplish. Bill?
If I have one thing, I think the most important thing that I would do differently in this case would be in one of my first case management conferences, especially if it's going to be remote. I would look the judge in the eye and go, Your Honor, what exactly are going to be your hours of operation? How long will we have per day to try this case? Because we ran into a case where we thought it was X and it was Y, and we gave our trial estimate in days. And a day to us was 2 of her days, and we ran into trouble. So if you're going to do it remote, you really have to work through, okay, Your Honor, what does it look like? What are you going to do? How much time? And then, especially with multiple defendants, work out how that's going to work, because that was probably, other than the merits and, you know, everybody talking about their coverage and all, but trying to fit what we thought was a regular trial into what the judge was going to do was probably the biggest problem we had.
That's a great point. Well, we're right at the top of the hour here, so in respect to everyone's time, I want to thank you all for participating and attending today's webinar. I think the main takeaway that I hope you gain from this conversation is that regardless of the case that you're working on, size, complexity, number of parties, it is absolutely feasible to continue taking depositions and moving forward through trial in a remote setting. Unfortunately, we don't have any time to get to your questions that came through the chat window, but please be assured we will send you a response to those at our earliest convenience. Once again, thank you all to our attendees and our panelists, and have a wonderful day.
Thank you.
Thank you.
Thank you.